Hello dear students, I am Sitaraman currently Vice Chancellor, Global University. Today I would like to discuss in this module the human rights lawyering Indian experience. I would like to broadly present my framework in 4 parts. I would begin by stating the journey of law in colonial context through the struggle for independence and the movements in the backdrop of that independence struggle. The second part, I would present the journey of civil liberties movement to begin with from the late colonial period, but moving into the post-independent period into the contemporary in various phases. The third part, I would present the emergence of a new professional human rights organization and therefore a new professional human rights lawyering interventions. And in the fourth part, I would conclude with broad observations on the nature of changing currents in human rights lawyering experiences, both within civil liberties movement as well as in the professional human rights organizations. Let me begin with the first point. The struggle for independence is very formative for all kinds of journeys that India has gone since independence. Whether it is making of the constitution, whether it is fundamental rights incorporation in the constitutional process, or a number of reforms, social reforms, economic reforms, and other reforms that were carried was squarely due to the influence of independence struggle. And therefore, we must understand how law facilitated or played a role in creating those debates and subsequently goals in the minds of national movement leaders. I would like to broadly state law is played a very important role in determining the colonial life in 18th and 19th centuries of India. That is broadly through creating a institutional edifice. We have early charters, creating new court systems, creating a whole paraphernalia of law enforcement and policing process. That was very, very critical. In a very similar way, we have a number of new legal frameworks that created property in land, whether it is transforming agrarian relations or transforming forest property question of tribals and so on. So we have a variety of legislations pertaining to land and forest, and we have a variety of legislations that created a whole legal infrastructure that would create a possible way by which the society is transformed into a legal modernity. In doing so, law played an ambiguous role. Law in the colonial context was, of course, a very oppressive tool, a strategy of the colonial masters in controlling, disciplining, and ordering the colonized. It obviously happened through a variety of draconian legislations, whether it is Regulation 3 of 1818, whether it is subsequent administrative or preventive detention laws that colonial masters created in order to prevent any upsurge in independence movement process. On the other hand, law also played a very important role in reforming the social fabric in India. We are all familiar with the 19th century social reform agenda of preventing child marriages, widow remarriages, contributing to widow remarriages, and such other social reform agenda, including prohibition of sati, was very much carried through the instrument of law. And therefore, this ambiguous point of simultaneously being an instrument of oppression and an instrument of social reform is continuous all through the colonial experience. The language of rights, as we see a little later in this module, the language of rights is intertwined with both these processes. I would begin with the oppressive aspect of law in terms of what law has done to the leaders of nationalist movement, and therefore creating a particular way of looking at civil and political rights question. I would begin with 4 major trials that we could recount. There are many numerous trials that happened all through the independence period. It is not possible to recount here. The work of, for instance, A.G. Noorani on political trials would give us a very clear idea as to the extent of some of these trials that happened. What I would certainly do here is simply flagging off 4 cases of that nature that would give us an idea as to the kind of cases that the independence struggle had witnessed. It began with the trial of Tilak in late 19th century to begin with, and early 20th century in the second occasion. The trial of Tilak on sedition, once again a major charge, crimes against crown, and he was prosecuted for the charge and then convicted. Subsequently, the trial of M.K. Gandhi, Mahatma Gandhi, in the post non-cooperative movement phase. Once the non-cooperative movement stopped by Gandhi after the Chauri Chaura, and he was tried, and in that particular trial, Gandhi defined what his civil disobedience philosophy is in the courtroom, which is very interesting and which is fascinating to really see. That is, while disobeying law, Gandhi was very much clear to say that I am willing to take my punishment. And even if you were to release me tomorrow, I would continue to do the same kind of disobedience, which is a very interesting engagement with law, but at the same time defying law. It's a particular kind of an ambiguous engagement that defines the way Gandhi looked at legal modernity in colonial context, which is also an important process to understand if anyone wants constitutional transformation to happen in any society. We also have 2 more trials that define the rights language in the late national movement context. One is the trial of Bhagat Singh, who disrupted the parliament proceedings, led to his arrest and then of course his conviction to capital punishment. Then of course the final one is a Meerut conspiracy case, which is a very famous conspiracy case of the Communist Party of India, including one of its famous leaders, Dange, being prosecuted in that particular case. All these cases were important because these cases created a possibility of talking about political trials, prisoners and rights of prisoners and such issues. So in other words, what is the question of freedom, freedom to talk, freedom to oppose, civil disobedience, questioning state, and of course once arrested, what kind of rights that a prisoner should have. And those are obviously the early days of conversation, and so therefore they played a very important role. So in that sense, through the oppressive mechanisms of law, we have seen some kind of discussion taking place. In a very similar way, the other oppressive legislations to recount are the Rowlatt Act of 1918, against which Mahatma Gandhi led a massive agitation, and we also know that the agitation led to a massive mobilization for a meeting in Jallianwala Bagh, and then of course a massacre happened when indiscriminate firing was resorted to. The Congress appointed a fact-finding committee, and none other than Mahatma Gandhi seemed to have written the fact-finding report, which is there in his collected works even today. I feel that's an important moment in civil liberties context in India, because that is one of the earliest fact-finding reports that could be recounted for. Subsequently, in fact, the Indian National Congress conducted a variety of fact-finding reports in different parts of the nation. In a very similar way, we had a massive movement in favor of civil disobedience call given by Mahatma Gandhi in early 30s that led to hundreds of thousands of Indian National Congress workers were imprisoned, and that created a massive debate on political prisoners once again. And this is actually the background against which the civil liberties idea has taken root, and subsequently the Indian Civil Liberties Union started in mid 1936. We will come to that a little later. The early language of rights, if we see, I would recount 3 or 4 major figures. There are many others, but I would confine to these 2 or 3 examples to illustrate the early work that already happened. The earliest official representation of rights language could be seen in the special session of Indian National Congress AICC in 1918 in Mumbai, where it resolved on civil rights issue in India, where first time Indian National Congress presented the problems of the subjects of the colony in terms of the language of rights. And I think that was an important moment because these rights, of course, nowhere close to the fundamental rights that we enjoy today, but at least articulated a clear position of representing the grievances, the individual concerns in the form of rights. The basic sum and substance of many of these early treatises is that Indian subjects must enjoy as many rights as an English subject has in the context of England. And I think that's the spirit in which the conversation happens in many of these early works. In terms of academic writing, S. Satyamurthy, a Congress leader, wrote Rights of Citizens in the year 1919. In a very similar way, V.S. Srinivas Shastri, who is a Liberal Party member, member of the Council of Viceroy, and a very prominent lawyer of his time and a contemporary of Mahatma Gandhi, played a very important role, and he delivered a variety of lectures on rights of citizens and man. Similarly, Ram Manohar Lohia, another prominent figure in Indian National Congress but belonging to the socialist faction, who wrote Struggle for Civil Liberties, which is a kind of a pamphlet at the beginning of creating Indian Civil Liberties Union. A very important book in terms of recounting the significance of civil liberties in late colonial times. So therefore, there are 2 important points to recount: that the language of rights emerged in the Indian national movement through both the oppressive processes as well as social reform processes, and secondly, it got consolidated with the emergence of a movement for civil liberties, which started with the formation of Indian Civil Liberties Union in 1936. I will now turn to a story of civil liberties movement in India. It is important to recount because civil liberties movement is the most organized movement that fought for political freedoms initially and subsequently human rights of all in the country. The movement began with the formation of Indian Civil Liberties Union in 1936. Well, it is true that Pandit Nehru played a very important role in the conceptualization of this particular organization. It is not very clear as to what really made this conceptualization possible, but the biographies of Nehru indicate that he met in 1927 Roger Baldwin, the founder of American Civil Liberties Union, who visited Brussels at the time for the Anti-Imperialist League meeting. Pandit Nehru happened to be in England, and he too was there in the Anti-Imperialist League meeting, and they seem to have met many times. And I would imagine speculatively that that was an important moment in which Pandit Nehru may have understood the significance of civil liberties movement in the freedom struggle in India. Of course, 7 years later, we have seen the formation of Indian Civil Liberties Union. Pandit Nehru took special interest in both the inaugural meetings of Bombay and Madras at that particular time. He was present, he gave the inaugural speeches. He conceptualized civil liberty as an essential right to oppose the state. And he clearly said, without civil liberty and without right to oppose the state, no democracy can survive. And that was an interesting sort of phase in which a political rhetoric of democratic processes was initiated in these forms. A Congress Socialist Party member, K.B. Menon, was the first General Secretary and who ardently worked for issues of press freedom, and in fact he wrote some pamphlets and so on that particular topic, and also fought for political prisoners. Jawaharlal Nehru, however, lost interest in civil liberties very soon, because by 1938 there were provincial elections in which Congress party contested and also came to power in many of those provinces. And in Bombay particularly, when K.B. Menon asked for release of political prisoners, which was a promise of the parties before the elections happened, Jawaharlal Nehru was visibly upset, and he wrote to many of his Congress members saying that K.B. Menon is working as somebody who belonging to the opposition parties, which is actually a kind of a political opportunism of certain kind. But that, I suppose, is explainable because Congress was early and therefore he was anxious. But nevertheless, his commitment to the norm of civil liberties was a little suspect from the very beginning, though he was very well articulate in terms of what the value is. After that, therefore, since there is no real support from Indian National Congress post 1938, the organization went into a little slumber, and by 1941-42 it was already a non-existent body. The second phase of Indian civil liberties movement can be counted from 1949 to 1960, which is the early period of independence. And during this period, Servants of India Society played a very important role, a Pune-based organization, in publishing Indian Civil Liberties Bulletin, a chronicle of representing human rights situation in India in the first decade of post-independence. It's a very important document, and in which we see all kinds of political parties, Congress Socialists, Jan Sangh, and many such political parties of opposition were very much taking part, of course except Congress, which was in position of power. And that was an interesting kind of conversation to see Nehru in position of power, while of course he was very serious advocate of civil liberties in 1936, and in the post-independent context he was being scrutinized by those who have taken the cause of civil liberties. Whether it is early preventive detention ordinance and then preventive detention law, or whether it is subsequent issue of Communist Party overthrowing in Kerala, or any of those kinds of issues obviously became hot debating points. And in fact, the first decade, preventive detention is a very important debate in these bulletins that I mentioned about. Then there is a small phase of 1965 to roughly about 1971-72, which begins with the split of Communist Party movement in India with CPI and emergence of CPIM in late 1964, and then of course onslaught of the Defence of India rules implementation by Congress government and arresting a number of CPM leaders. Interestingly, Mr. N.C. Chatterjee, a member of Hindu Mahasabha but a prominent lawyer, played a very important role in defending the cases of those who were arrested from the Communist Party, and subsequently travelled across India to create a civil rights movement in that particular time. That continued into a movement of violent upsurge that happened in a remote part of Bengal called Naxalbari, which subsequently became a Naxalite movement or a Maoist movement, which created hundreds of political prisoners overnight. And there is a great concern by middle class intelligentsia both in Bengal as well as elsewhere, and subsequently in southern states of Kerala and Andhra Pradesh, in defending the political prisoners' cases. Many of these violent movement leaders were arrested under similar provisions as colonial laws, under which the national movement leaders were arrested. There were charges of sedition, treason, and so on and so forth. And so there was actually a need for legal aid movement, and the early civil liberties movement of 1960s and 70s was largely creating momentum for pleading the cases of political prisoners. And that was the beginning of a new era in civil liberties movement. The final sort of current phase can be traced back to post-emergency. As all of us are aware, there was an internal emergency imposed by Prime Minister Indira Gandhi in 1975, and it was finally lifted in 1977. And when there were elections in 1977, Janata Party came into political power. In the post-emergency phase, we see the revival of civil liberties movement taking place across India. Both national organizations as well as a number of state level organizations have come into being once again. I would confine to just name some of these organizations in order to simply indicate what those are. I would not go into the details of the histories of these organizations, as we will not be able to provide space for that in this module. Post 1977, we have witnessed the revival of PUCL DR, or People's Union for Civil Liberties and Democratic Rights, which was originally initiated during emergency in 1976. The PUCL DR became a little ambiguous because some of the Janata members, such as Chaudhry Charan Singh and so on, felt that the purpose of civil liberties movement is over because they were fighting Congress and Congress is ousted, and therefore we don't need any civil liberties movement after that. It led to a little impasse, but finally some intelligentsia came together and revived PUCL DR, and soon, of course, due to differences, the PUCL DR breaks into PUCL and PUDR. In a very similar way, there are a number of regional organizations, the Andhra Pradesh Civil Liberties Committee in Andhra Pradesh, Association for Protection of Democratic Rights in Calcutta, Committee for the Protection of Democratic Rights in Mumbai, or many other sorts of organizations, Lok Shahi Haq Sangatna in Mumbai, or OPDR in Andhra Pradesh, and Naga People's Movement for Human Rights in Northeast. You have a variety of such civil liberties groups that came into existence in the post-emergency context, who continue to function, many of them, in one or another factional form even today. I would more focus on the kind of debates that happened very quickly. Some of the key debates of these organizations were, what is the role of civil liberties movement in a democratic society? Should it take up the cause of only political prisoners and political activists, or should it really take the wider cause of rights of people at large, and within which, of course, the rights of political prisoners becomes one part? The second approach is whether the civil liberties movement should be neutral, or should it take a position vis-a-vis the questions raised by political movements. And most importantly, the third question I could say as an important debate that happened is, what should be the approach of civil liberties movement to the violence of non-state actors? In other words, Maoists or the Naxalites at that point of time were and continue to engage in means of violence in terms of their political action, and whether civil liberties movement has an obligation to take a position on that particular forms of violence. It was a divided and controversial topic. There is a lot of debate about why it should or it should not, and it is still probably unresolved, but there is greater consensus today that no violence of any kind in principle be acceptable to a civil liberties and a human rights movement. And that being a kind of loose consensus subsequently redefined the political debate as it happened in the civil liberties movement context. The civil liberties movement continues to be very active in different parts, and also the national level PUCL and PUDR are very active organizations. But given the kind of human rights questions that arose, given the massive nature of the country, the civil liberties movement has never been able to adequately address all the concerns that emerged for human rights. As a result, while the civil liberties movement continued to do whatever it has been doing, both within the political movement context as well as the wider context of civil liberties of citizens of India, we have witnessed the rise of a specialist professional human rights organization emerging in the 1990s. During the 1990s, the professional human rights NGO emerged. Of course, there is a background to it. There is possibility of international concern growing. There is also a backdrop of establishment of national human rights institutions and a growing international consensus after the Paris Declaration to establish ombudsman agencies to protect human rights in many countries. India already moved to legislate upon in creating a National Human Rights Commission in 1990s. Before that, we already had certain other kinds of commissions. In this background, there is need arose for the place of a professional organization that would engage with both the processes of the court, which already is doing public interest litigation, and the new agencies that came up for protection of human rights specially. It is in that context that we have seen a plethora of human rights organizations emerging, and their number, unfortunately we do not have any codified statistics of how many hundreds of such organizations we have in India. There are some prominent ones, but what I would confine here is to classify them into certain groups. One type of human rights organizations are those which try to create a network of human rights lawyers across the country. For instance, the work of Human Rights Law Network, a Delhi-based organization which also has an office in Mumbai, is an example of creating a network of human rights lawyers across the country. The emergence of a professional human rights organization in 1990s happened in the following backdrop. There was growing international consensus of establishing national level human rights protection mechanisms such as the ombudsman agencies after the Paris Declaration. The Indian National Human Rights Commission's legislation also passed in 1994. In a very similar way, there was growing concern as to the inadequacy of civil liberties movement's capacity in addressing the specialist needs of groups fighting for their own rights, such as children, such as sexual minorities, and so on. Besides this, we must also recount that there was an interest in the philanthropic organizations in terms of funding rights-based activity. The role of Ford Foundation particularly is to be recounted, but there are many other organizations, bilateral developmental agencies, such as the civil society funding groups from Netherlands and Switzerland. So you have a variety of philanthropic organizations who were very keen to facilitate human rights action in third world societies. I would however confine here only to provide a broad classification of these groups than getting into the details. Some of these details we will see as specific modules of case studies subsequently in this chapter. There are 3 or 4 kinds of specialist human rights organization I would like to recount. The first one is creating human rights lawyers network across the country. This is a model pursued by the Human Rights Law Network, a Delhi-based human rights organization, actively creating a network of human rights lawyers across India. This is a model obviously very, very interesting, but not always with great success. I think the case study will reveal the kinds of issues that the organization had to face. Then we have certain groups that work towards creating legislative lobbying and advocacy, besides of course courtroom litigation. A group like Lawyers Collective comes to my mind as an important organization that played a role in these strategies. Then we have a set of organizations that worked creating activist lawyers through advocacy. But this is not a network, but creating activist lawyers by engaging with them, hand-holding them, and creating interest in human rights lawyering. Center for Social Justice, Ahmedabad-based organization, comes to my mind as an important example for this kind of thing in North India, and People's Watch, Madurai, in the case of Tamil Nadu. And finally, I would say alternative lawyering opportunities through a kind of affective engagement with young lawyers is the model that I would like to present as something that happened in this professional organization creation. The examples that come to my mind are the Alternative Law Forum in Bangalore and Majlis in Mumbai are very, very close to this kind of example. These organizations have been doing quite well. They have done great work so far. But we will see the case studies in terms of the details of the kind of work that they have done so far when those modules arise. But at this point of time, it is suffice to recount that everyone seemed to be under pressure for the simple reason that there is a changing context of global economy, there is a changing context of human rights jurisprudence, and there is also a changing context of available fund to support the activities of rights-based organizations in Global South. And given this kind of a change, I would assume that these organizations would have a greater constraint in performing the tasks that they did during 90s and early 2000s effortlessly. But we will see as we go what's the kind of role they are performing. For this moment, it suffices to recount that there is a professional body of organizations fighting for human rights and civil liberties in this country at this point of time. Thank you.